Hello everybody, welcome to Ramesh Academy. I am your trainer Prachi Shah. Yes, in our previous recording we have spoken about various types of company. As I told you in our last in the previous recording that we'll be completing the types of companies in today's class, okay? And then we'll start with drafting of MOA and AOA. Now I suppose like in your foundation level few things you already know. This foreign company, I think you studied in too much of detail while you were appearing for your foundation. So I think this is just a recap of what you have done. In very well you know about the provisions of this section, that is starting from 376, 379, 380. So all the provisions of foreign company. I gave you just the introduction yesterday in our previous recording. What do you mean by foreign company? And I told you in detail about the provisions, about the Companies Act, what all attracts to them, what all compliances are needed. We will be doing it in detail in our following classes, okay? So here we saw that two important thing when it comes to foreign company, you have to remember, see, it says like when I talk about foreign company, only two things you have to remember. One starts with foreign company. Two things, okay? One, they say that it has to be incorporated outside India. First very important thing, how will you consider a particular company as a foreign company? One is incorporated outside India, first thing. And second, I repeat, one important thing is incorporated outside India, and second, having a place of business in India. So you have to remember these two things when it comes to foreign company. One, it has incorporated outside India, and second, which has a place of business in India. Now here guys, this when I say having a place of business in India means physical place hai, virtual hai, or in any form, okay, be it physical, be it through agent, whether you do it personally, or if you use all your electronic devices, you use all your social medias, email, whatever mode you use. If by any chance you are generating any income or you are conducting any business activity in India, then you will abide or you will have to abide with the provisions of a foreign company. Understood? So if you are incorporated outside India and if you are conducting business in any manner in India, I repeat, any manner, okay, it can be physical, it can be electronical, it can be through mails or any form, okay, it will be considered as a foreign company. Now recently I was just going through something and one of my students asked that, ma'am, you say it has to have a place of business in India or it has to have some activity happening in India. Now supposingly I am sitting in US, okay, through mails, okay, if I am contacting a client of India through email, okay, and everything is happening via electronic mode, okay, physically I am just not present over there, then I do not have any office over there, I have no connection on your Indian land, okay, then how do you say that the provisions of Foreign Companies Act would attract to me? Then the answer is, the definition of foreign company includes place or any business activity, whether it is physical, whether it is through agent or through electronic medium. So two very important things, if you are incorporated outside India and in any form, I repeat, and in any form, if you are generating any business in India, okay, then it is considered as a foreign company. Clear? So these are the two important criteria. Now see, what are they trying to tell you here is, see, foreign company means any company or body corporate incorporated outside India which has a place of business, in India, whether by itself or through an agent, physically or through electronic mode, and conducts any business activity in India in any other manner. So if you are doing any matlab kuch bhi business, if it is arising on the land of India, then it will be considered as a foreign company. Okay. uh, Section 379 says 393 under chapter 12 or 22 of the act deals with such company. So this is important. So from starting from section 379 till 393, all the sections are of the foreign companies. Okay. Guys, one very important thing I'll clarify. I am very bad at remembering the section numbers. Okay. So kabhi kabhi there will be chances wherein if I'm teaching you something, तो वो सेक्शन यहाँ वहाँ इट माइट हैपन. ओके. प्रोविजंस गलत नहीं बताऊंगी, डोंट वरी अबाउट दैट, बट नंबरिंग में आई माइट हैव इश्यूज. आई ऑलवेज हैव अ प्रॉब्लम विद नंबर्स. सो यू प्लीज मेक श्योर दैट वट एवर इज देयर इन द बुक सेक्शन आप प्लीज वेरीफाई कर लेना वेर एवर आई स्पीक. प्रोविजंस एकदम परफेक्ट बताऊंगी, डोंट वरी अबाउट दैट, but the problem will be with the section numbers sometimes, not always, because I am trying really hard to remember the sections, but I cannot. And one very important thing for your exam also, if you are 100% sure with respect to any section, then only mention that section number. Otherwise, please don't do that. I repeat, if you are 100% sure and confident that the section number that you are showing or portraying is correct, then only you are supposed to write it. Otherwise please don't write it, because nahi likha to uska marks cut nahi hota, but if you write it wrong, then of course your marks would be deducted that way. So if you are sure, of course you write it, it beautifies your answer, it shows to the evaluator that this person has really worked hard on the subject. It is very good if you write, but it has to be correct. Galat mat likhna. Okay. Now see what they say. Let's start with 379 is about 379 section is about the section wherein you will consider a foreign company as an Indian company. So what are a few criteria, like in case if the 50% or more shares of a foreign incorporated company is taken over or acquired by any Indian company or any citizen of India, that's when you will consider that foreign company as an Indian company. So section 379 is about that. We will of course do it about that in this only thing, but they have first tried to start with section 380. Reason being, they are telling that in case if it is a foreign company, okay, and if they have acquired or if they have started their business in India, okay, what all provisions you will have to comply with. So first thing is section 380 talks about what, that supposingly ABC Limited company is ABC a company hai, okay, we have opened it in Chicago. Now they have started their business activity in India. Then what all compliances under foreign companies they will have to comply with. So section 380 deals with that. So what they say, see, they say that section 380 of the act lays down that every foreign company which establishes a place of business in India within 30 days of the establishment file with the registrar of companies for registration. So guys, just please write down over here form, can you see this? Okay, form FC1 has to be filed. Okay, so from the date these people have made a place of business in India, supposingly on 1st of April they did their first work, then till 30th April FC1 has to be filed with ROC. And what all things would be there? See, a certified copy of the charter, statutes or memorandum and articles of the company or other instrument constituting or defining the constitution of the company, and if the instrument is not in English language, a certified translation thereof in English you have to file. So what they are saying, supposingly a company is a Dubai based company, okay, this is one Dubai based company, और उनका जो भी charter है, like how we have MOA, उनका जो भी whatever it is, if it is in Arabic, okay, then you this charter, okay, has to be translated in English and certified copy, okay, that yes, this is whatever is written is true, you will have to get it certified, okay. So that certified translated copy of the charter has to be filed in form FC1. So these are the attachments which they are talking about. See what they told. Section 318 of the Act lays down that every company which establishes a place of business in India within 30 days of the establishment of such business, file with ROC for registration. Okay, so what you have to file? File form FC1 within 30 days from the date you have made a business activity in India. And who will file it? The foreign company will have to file it. Okay, so foreign company will have to file form FC1 foreign company will have to file form FC1 within 30 days of starting business activity in India. Okay, now uska first attachment is the charter of that company. So if it is in Dubai, so Dubai ka jo bhi main us company ka whatever is the charter document, like how in India we have MOA, वैसा वहाँ पे जो भी होगा whatever is that document needed, okay, that you will have to give it to ROC India also, and accordingly in which area you are setting up the business. Okay, तो उस particular ROC, supposing you are starting the business activity in Gujarat, so you will have to register it with ROC Gujarat there. Clear? So this is the first thing. Second, what they are saying, that the full address of the registered or principal office of the company. So in Dubai, where is your registered office? That you will have to give. And second, you will of course have to give the office or the place where you are doing the business in India also. Okay, so first what you have to give? The place or the principal registered office of the country from where you are coming. So the foreign company wala. So here they are talking about the full address of the registered principal office of the company. Which company? Foreign company. Okay, then a list of director and secretary of the company containing such particulars as will be prescribed. Now guys, why are they asking this? Because here a resident director is needed. Okay, I don't know why it is like this, because here one resident director is there. If you guys have studied this concept of alternate director, it came from this. I think you guys are still not aware about this concept, so I don't want to touch it. Once we do directors, once I teach you what is alternate directors, that's when we will speak about it. But owing to all these reasons, okay, the concept of alternate director came into picture. Now this is something which is untouched for you right now, so let's not go on that because abhi uski zarurat nahi hai. But you just have to remember one thing, that because there is one resident director, we need to furnish the detail of the directors of the company. Okay, the name and address of one or more person resident in India authorized to accept on behalf of the company service any notice etc. to be served. Why you have to give details? Reason being that whenever any meetings are happening or any important documents have to be served, we need a person from India. Okay, that's why that person's name, address, all the documents, all the particulars of that person has to be known. Understood? For this reason, for communication purpose, because for foreign company, this particular person is from India, who is exclusively responsible for working in India. So whatever notices, suppose ROC has to send something or communicate something, it will be done to this person. Clear? And the full address of the office of the company in India, as I told you, one would be, this is foreign wala and this is India wala. So both has to be communicated in form FC1. Then particulars of opening and closing of place of business in India on earlier occasion. Now why this declaration or clarification is needed? Reason is, that supposingly if you have come to India in past, okay, and what if you have done any fraud or if you've done something wrong on Indian land, तो हमको कैसे पता होगा that because you are a foreigner and we have no clue or base about you. So in case if you have earlier come to India, what work were you doing, why did you leave India, all that declarations have to be made and you have to clearly specify about it, so that in no chance you are here to do a fraud or any wrong on the land of India, so that ROC has a clarity about it. Clear? So then what they say, declaration that none of the directors of the company or authorized representative in India has ever been convicted or debarred from formation of the companies and management in India or abroad. So in case if you are a foreign company, you must not be debarred from making a company on foreign land also as well as on Indian land also. Clear? So this is a must that you have to give a declaration that we are here with a clean intention for doing business. मतलब हम लोग कुछ गलत करने नहीं आए. So ROC here also should know, and you have to give a declaration that we are pure clean chit on that land also. Getting the logic? So for that, all this clarity has to be submitted to ROC here. Clear? This is in form FC1 and foreign company has to file within 30 days from the day you are starting any work in India. Clear? Now every foreign company has to ensure the name of the company, the country of incorporation, that the fact of the limited liability is exhibited in specified places or document as required under section 382 of the Act. So you have on your letterheads, on your name plate, all your business communication, everywhere the company's name, the date of incorporation, the name of the company, the place, the country of incorporation, whether you are limited by guarantee, by shares, unlimited, whatever it is, okay, everything has to be maintained and you have to tell that. Clear? Now comes 376 of the Companies Act provides that when a foreign company which has been carrying on businesses in India ceases to carry on such business in India, it may be wound up as an unregistered company under section 375 to 378, even though the company has been dissolved or ceased to exist under the laws of the country in which it was incorporated. So even if you have done the winding up process over there, you will have to do the winding up procedure here also. Now guys, we say no, ideally unregistered were the ones I told you while we were doing the types of company, that unregistered are the one that which we get through kings and queens, okay. So here, so when I say about foreign company, they are not incorporated on the land of India, okay. तो हमारे पास जो winding up provisions है, we are having the provisions regarding the companies which are incorporated on India and winding up of them. So companies which are not incorporated on the land of India, okay, like how East India Company अपना नहीं था, we got it through Queen, तो उनके लिए what we had unregistered company. So the concept of winding up of foreign company comes up from unregistered company because it is not registered here. So how you wind up unregistered companies, we have to similarly apply with those provisions here also. Okay, so section 376 says that for foreign company we have section 379 to 393, but 376 में ये बोला गया है that in case if your company is a foreign company, this is how it will be done, the winding process. Clear? So these are the winding up ke provisions, that's why they are talking about that. Now section 379, as I told you, this is the starting section which says that in case, see, so please write down over here, when to consider foreign company as Indian company. Over here, these are the provisions of winding up of foreign company. Clear? Now 379 provides that where not less than 50%, so 50% से ज़्यादा, okay, paid up share capital whether equity or preference or partly equity partly preference of a foreign company is held by, write down please, see, more than 50% of paid up share capital, be it equity or preference or both, equity or preference, okay, or partly it's or half, partly equity or partly preference, is held by one or more citizen of India. First, second, there is or in between, huh guys, or one or more body corporate, or so either one or more citizen or one or more body corporate or citizen and body corporate together, okay, jointly, aggregate. So either of in either of the situation, okay, foreign company will be considered as Indian company. Clear? So what are they trying to tell you here? See, 379 provides that where not less than 50% of the paid up share capital, whether equity or preference or partly equity or partly preference of foreign company, is held by one or more citizen of India or by one or more body corporate in India, whether singly or in aggregate, such company shall comply with the provisions of this act as they prescribed with the central government with regard to business carried on by it in India as if it was incorporated in India. So what all the provisions which applies to Indian company, you will have to comply with all of them. Clear? Now 381, okay, requires, so so far 379 and to consider foreign company as India. 380, the moment you start in any activity in India will be 380. What all compliances you will have to do. Now 381 requires foreign company to maintain books of accounts and file a copy of balance sheet and profit and loss account in prescribed form with ROC every calendar year. This is not financial year, my students, it is calendar year, okay, and this accounts shall be accompanied by the list of places of business established by the foreign company in India as to the date with references to which the reference of balance sheet is made of. So you have to file balance sheet and PNL with ROC on calendar year basis, and apart from that you have to maintain all your books of accounts, okay, as it is needed by Companies Act. And apart from that, where all in India you are carrying on your business, you have to disclose about that also in your balance sheet. Clear? Now as regards to the applicability of the provisions of the Companies Act, the following provisions of section 384 are noted. Provisions of section 71 applies to foreign company, that is about debentures, same, okay, no exemption. Annual filing के जो भी sections है and CSR subject to such exemptions, modification, adoptions as may be made therein by rules made apply to foreign companies. So whatever exemptions are given, okay, apart from that the provisions of annual returns and 135, that is CSR, would apply to foreign company. Provisions of section 128 shall apply to the extent of requiring it to maintain at its principal place of business books of accounts. So with respect to monies received and spent, sales, purchase made, assets liability in the course of or in relation to its business in India. So all these things also you will have to file, okay, maintain. So provisions of chapter 6, charges as it is. So how it applies to Indian company, it will apply to a foreign company also. Provisions of chapter 14, that is inspection, inquiry and investigation. So three chapters, that is debentures, charge and inspection, inquiry and investigation, shall apply as it is to a foreign company. Clear? Now as per section 386, having a share transfer office or registration office will constitute a place of business. Okay, so in case if you have any STO or any registered office, okay, it will be constituted as a place of business. It was in this case it was held whenever a representative of a company incorporated outside the country frequently stayed in a hotel in England for looking after the matters of business. It was held that the company held the place of business in England. So though you did not have any particular official residential address, okay, to carry on the business, you were staying in a hotel to do your business, then also it will be considered that yes, you had a place of business in England as well. Okay, in certain cases it was held that mere holding of property cannot amount of having a place of business. See, just because you have done some investment over here doesn't mean that you are a foreign company, matlab you have a place of business in India. That will not count. Okay, but for business purpose, if you have come to this place and even if you're staying in a hotel, it will be considered as a foreign thing. Now see, they have given you a list of companies which can be considered as a foreign company. तो उसमें क्या लिखा देखो, India, America have a stock. Some of the renowned American companies are Amazon has a place of business in India. Citibank, Coca-Cola, Ford India, Google, American Express, PepsiCo, Hewlett Packard, IBM, JP Morgan, Adobe, Apple, Microsoft, so many companies. Okay, so all these are examples of the foreign companies, though outside India, but they have a place of business, they are doing something in India, then they all will be considered as a foreign company. So now guys, to open one line I forgot to give you. See, in case if the foreign company is opening any branch office in India, then to open branch office, okay, FNCY, I don't know what is wrong with this pen, I really don't know. So to open a branch office, guys, remember form FNC1 has to be filed with ROC. So we saw form FC1 the moment you have a place of business in India, and FNC1 in case if you are opening a branch office in India. Okay, so this is about foreign company. Two important things, whether if you where you have to be incorporated in India and have any place of or any form of business in India. It can be physically, it can be electronic mode, in any form. Okay, if you are generating any source of business in Indian land, you have to abide by that. Then section 379 talks about when will a foreign company be considered as an Indian company. When more than 50% of your paid up equity or preference or both, okay, are held by any citizen singly, jointly, any one or more body corporate, or either in aggregate, little bit by citizen on body corporate together. Okay, if you have more than 50% of the capital of foreign company, then it will be considered as an Indian company, and all the rules, bylaws, whatever is applied to Indian company would be applied it to them also. Then 380, in case if you have started working in India, what all things you have to give. So your charter, the place of business outside India, inside India. Then who are the directors of your company, whom the notices have to be served, and in case if you have come to India earlier, what work were you doing and why did you go, all that clarification you want. And you have to give a declaration that all the directors of your company are not debarred to form a company on your land also and on our land also. That will be form FC1 with all these clarifications. Okay, then they say that you will have to maintain all your books of accounts, you will have to file your company ka balance sheet and P&L, and you will have to specify all the places of business where you are doing your work in India. Okay, then they say that what all provisions of winding up, in case if you are planning to wind up your work in India, then in that case all the provisions of unregistered companies winding up will apply to you. Even if you are wound up in your foreign land, here India ke winding up provisions also you will have to comply with. Okay, and what all sections, so charge, inspection and debentures, this will as it is applied to you. And there are other sections like annual return, section 135 CSR, उसमें certain exemptions छोड़ के they will apply to you. So this is about foreign company. I hope each one of you is very clear. Okay, we have studied about all this in our previous sessions, but it's been almost 6-8 months we have not touched that. So I just gave you a recap of what is foreign company. I hope it is clear to everybody. Yes guys? Okay, I give you a minute's time to just go through before we start with drafting of MOA. Just go through that please. Yes guys, memorandum of association. Now like how in India, if you see, we have a constitution, okay, and constitution is a charter document and anyone cannot go beyond constitution. Okay, so each citizen of India gets the rights from the constitution: right to live, right to freedom, right to equality, democracy. So however or whatever is your government or whatever, however you are supposed to work or you are supposed to act, it goes by the constitution of India. Okay, so the constitution is your charter document and anyone cannot go beyond that. Okay, so whatever is written in the constitution, no act, no person, okay, or no authority is beyond the constitution. It is your charter document that this is the ideal और इसके purview के बाहर आप नहीं जा सकते. This is something wherein you do not have anything or no scope beyond that. That is like constitution. Okay, same goes with memorandum of association. Memorandum of association is a charter document for any company. Okay, and no company, whichever, like however big you are, okay, you cannot go beyond your memorandum. So it is one document which will give you all the powers, okay, how you are supposed to act, what all you are supposed to do. Say for example, if you are a private limited company, okay, then your memorandum would say that minimum 2 members are needed, 2 subscribers to MOA are must. Okay, तो उसके बाहर आप नहीं जा सकते. You cannot incorporate a private limited company with 1 person. So that OPC is a different thing. Okay, say for example, if you are starting a public limited company, okay, and MOA में it said that you need to have minimum 7 members to start up this company. So in any given time you cannot have 6 members. Getting the logic? So whatever MOA is the borderline within which you have to act. Say for example, in MOA your authorized capital is 50 lakh rupees. So whatever happens in any given chance, your capital cannot go. Of course, through special resolution you can alter the clauses, that is a different thing, but you cannot go beyond this. This is the maximum. Say for example, your object clause specifies you will do so and so, तो आप उसके बाहर नहीं जा सकते. Suppose your object says that I will manufacture cloth, and tomorrow you cannot go and do furniture. Getting the logic? So MOA is a charter document and you will have to abide by whatever is written in that. You cannot go beyond them. Okay, so what is your name? Okay, how much capital? That is company limited by guarantee, company limited by shares, company limited unlimited. It is guarantee having share capital, guarantee having not share capital, no share capital. So all that you have to first say, that will be a liability clause. Your capital, so how much is your authorized capital? You have to say this is the authorized capital. So this is the maximum amount of capital which any company can raise. Okay, then after that you have name clause, so which will tell you that what is the name of the company. Then second is your object clause. Object will tell you why have you incorporated yourself, what work will you do. Okay, that will be your main object and any other object. So these two things. Then of course situation, so where is your registered office situated, that you will have to say. Then fourth is your capital, I told you. Then your liability clause, what would be your liability? It will be limited, unlimited, limited by guarantee, what it is. Okay, so this 6 clauses are part of your, and of course the last page, that is your subscription clause. So who are the subscribers? So who are the initial members of your company? So all these things would be part of your MOA. Now in this thing, that is in this topic, we will be seeing that what all things you will have to consider while you are drafting an any MOA. Okay, so in case if your company limited by shares, so which is the ideal format you will have to take, or you will have to abide by which form? Okay, so that is table A is is prescribed for that, so that you will have to use, of course. And you can always draft your own thing which you will have to get it approved by the ROC. तो वो कौन से format में होगा, that all has been prescribed in this act. Then we come to name clause. So how you're supposed to name your company, what all names are not available, which all names you will are restricted by government. Okay, for which names you will need approval of central government. So all that we will be seeing. So all this with respect to MOA we'll be studying in this particular topic. A very important thing, like tomorrow when you are planning to incorporate any company of your client, you should know all this. That's why we are studying about the setting up of business. So in initial setting up, what all you will have to do, and after that of course we will see that how we are supposed to do the incorporation on MCA portal. If any of you are in the articleship mein ho aap, so you will be knowing it very easily, so it won't be difficult. So you guys will be aware what ma'am is telling. So linking practical with theory would become very easier for you then. Okay, so guys, let's read what is MOA first, guys. Section 256, if I am not wrong, 256 of the Companies Act has given a definition of memorandum. So what they say, memorandum means memorandum of association of a company as originally formed and altered from time to time. So say what alteration, like if you're changing the object of the company, like if you're changing some name of the company, like in case if your capital you want to increase, so if you have altered also it from time to time, then that also is part of your, those alterations are also part of your memorandum. Okay, in pursuance of any provision, previous company law or this act. So previous company law is 1956 or any of this act. Section 4 of the act specifies in clear term the content of this important document, which is the charter of the company. Memorandum of a company contains the object of the company which it shall pursue. It not only shows object but also determines the scope of the operation beyond which actions cannot go. So you have a main object and ancillary object, दोनों दिया होता है. So that is basically the scope beyond which you cannot go. So what they are trying to tell you, see, memorandum of association, that is MOA, is a document which sets out the constitution of a company and is therefore the foundation on which the structure of the company is built. It defines the scope. So till what can you work, how can you work, it will give you that this is the borderline within which you have to operate. Okay, then the first step in the formation of the company is preparation of a document called as MOA. In fact, memorandum is one of the most essential prerequisites for incorporating any form of company under Companies Act 2013. Okay, this is evidenced in section 3 of the act, which provides the mode of incorporation and states that a company may be formed for any lawful purpose by 7 or more members when the company is a public, and 2 or more when it is a private company, or 1 or more when it is an OPC company, by subscribing their names or his name to memorandum and complying with the requirements of the act for its registration. To subscribe means to append one's signature or mark a document as an approval or attestation of its contents. Okay, so we will see what it is. See guys, section 4(6) as we were reading of the act provides that memorandum should be in any one form specified in A, B, C, D, E of schedule 1 of the act, as may be applicable in relation to the type of company you want to propose. Supposingly, table A is for company limited by shares, table B is applicable for limited by guarantee. We know what is company limited by guarantee, we know what is company limited by shares, not having share capital. C is for company limited by guarantee, having share capital. D is applying to companies, unlimited companies, not having share capital, is applicable to unlimited companies having share capital. So ideally what we see is this form, table A wala, company limited by share. Ideally like in practice what in real life we see is company limited by shares. Okay, तो वो जो दूसरे सारे हैं that doesn't come to you very often, but of course it is there. So these are the 5 types of MOA. Remember, A is for company limited having share capital, B is company limited by guarantee not having share capital, C is for company limited by guarantee having share capital, D is for company limited unlimited, okay, unlimited companies who do not have share capital, and E is for unlimited companies having share. Clear? Now come to this contents of MOA. So basically these are the 6 clauses: name clause, situation clause, object clause, liability clause, capital and subscription. So these are the 6 main topics. Okay, now इसमें सबसे first we will be talking about name. Too detailed study it is, name clause का, okay, what all you will have to see, how do you finalize a name. So first thing that you will have to remember in name clause is adding the word public limited or private limited. See, as per section 4 of the memorandum of a limited company must have the following clauses. First is name clause. The name of the company with limited as its last word in case of public limited company, and private limited as it's the last word in the case of private. This shall not apply to companies registered under 8. That we have already seen कि section 8 company में private limited or limited लिखने की कोई ज़रूरत नहीं. Similarly, in case of government companies also, you do not have to write this. So they are the statutory companies and they have been in this. Okay, they are exempted from this. Then OPC will write OPC behind them. See, Tata Foundation, there is nothing like that. And in case example section 8 नहीं, example of OPC company, Chaffel House OPC private limited. ठीक है, so these are the basic things you have to remember. In public limited you write limited, in private limited ये क्या किया है, lifestyle media broad, this is also public limited, they have made a mistake here. Okay, this is section 8 and this is OPC. ठीक है, so this in case of private limited you have to write private limited, ऐसा नहीं चलता है. Okay, so this is your thing. Now according to section 4(2) of the name stated in memorandum shall not be, please these are very important, be identical with or resemble too nearly to the name of existing company registered under this act, be such that its use by the company will constitute any offence under the act or is undesirable in the opinion of central government. So if you keep any offensive name, number 2, like if you use any abusive word like Pagal Limited, I cannot do that. Okay, so I cannot register a company with any offensive name, something which is undesirable. And third, which is already present. So be supposingly, if why you cannot use a name of a company which is already present, one main reason of that is, guys, supposingly Tata Foundation, Tata company hai, it is already incorporated. Now tomorrow if I also incorporate with the company Tata's करके मैं incorporate करना चाहूँगी, so will central government allow this name? The answer is no. Reason being कि though I am not associated to Ratan Tata, if I keep identical name, people might think कि ये भी Tata का product है. Getting the logic, and the goodwill which I have not created for myself, I will take benefit of that. So the goodwill which Tata Group has created for themselves, if I use the same name, I might either ruin that goodwill or I might get advantage of that goodwill. But वो सामने वाली company के साथ तो injustice हुआ ना. That's why you can never use a name of the company which is already registered. Okay, so I will tell you how do you check on MCS site. See, identical names. See, rule 8 of companies incorporation rule 2000 provides that before granting any name, it will be examined whether the name is identical with the name of any other company or LLP or any other name already allowed to a company. to determine whether the proposed name is identical with other differences which are arising on account, the following are to be disregarded. Okay, see the words like private, PVT, OPC, PVT, all this सेम ही है. सो अगर प्राइवेट लिमिटेड और पीवीटी भी लिख दोगे कि सपोज ग्रीन टेक्नोलॉजी लिमिटेड और एलटीडी की जगह पे आप LIMITED फुल लिखो, देन इट विल बी डिसरिगार्डेड. वो डिफरेंट नहीं है, इट्स वन एंड द सेम थिंग. सी दे हैव टोल्ड यू द प्लूरल और सिंगुलर इन बोथ द नेम. से फॉर एग्जांपल ग्रीन टेक्नोलॉजी लिमिटेड इज सेम एज ग्रीन्स टेक्नोलॉजी लिमिटेड. SM computer is not same as SMS computer क्योंकि ये plural नहीं है, that is a different name. Getting the logic? So if you are doing singular plural, it will be considered as one and the same. And if green technology is already in existence, green's technology name you will not get. Okay. Second, they say ABC Limited is same in case if you put dots or you do the spacing, so that will not change the name. It will be considered as the same name. So if this is already in existence, okay, and if some new company or some new person is trying to apply for this name, our central government will not allow this name, and neither this, because you put dots or spacing doesn't mean name change ho jayega. Getting the logic? Okay. Then they say use of different tenses. Say for example Ascend Solution Limited is same as ascended or ascending. अब उसको कंटिन्यूस या पास्ट टेंस में कर दोगे, दैट डजंट मीन द नेम चेंजेस. ओके, सो वो नहीं चलेगा. देन केमटेक लिमिटेड इज सेम एज केमटेक लिमिटेड, और एक यू मेक लिटिल चेंजेस इन द स्पेलिंग, CH का K कर दो या S का Z लगा दो, सो दैट डजंट मीन द नेम इज चेंजिंग. उसका प्रोनाउंसिएशन इज वन एंड द सेम थिंग ओनली. देन दैट केस ऑल्सो इट विल बी कंसिडर्ड एज सेम एंड यू विल नॉट गेट दैट नेम. से फॉर एग्जाम्पल अल्ट्रासाउंड्स लिमिटेड, ultrasounds.com लिमिटेड, वो भी नहीं चलेगा. देन रवि बिल्डर्स एंड कंस्ट्रक्ट कॉन्ट्रैक्टर्स लिमिटेड इज सेम एज रवि कॉन्ट्रैक्टर्स. सो इफ यू इंटरचेंज द नेम लाइक दिस, बिल्डर्स एंड कॉन्ट्रैक्टर्स की जगह इफ यू डू कॉन्ट्रैक्टर्स एंड बिल्डर्स, then in such case also those names would be considered as identical only and no new applicant will get permission to use those names. Then use of definite or indefinite. See, congenial tours and travels is same as a congenial or the congenial. So उसके article या vowels add करने से name change नहीं होता. Then if you make slight change in the spelling, like COLOR color का COLOUR if you use, then that also will not be allowed. Then National Electricity Corporation Limited, if you are translating in any other language, in Hindi, Kannada, Urdu, any form, okay, but is उसका मीनिंग सेम ही है. सो नेशनल इज राष्ट्रीय, इलेक्ट्रिसिटी इज विद्युत, कॉर्पोरेशन इज निगम, इट्स वन एंड द सेम थिंग ओनली, एंड दैट इज ऑल्सो नॉट अलाउड. एडिशन ऑफ द नेम of a place to an existing name which does not consist, see, in if Salvage Technology Limited is an existing company, it is same as Technology Delhi Limited. So in case if you are adding just a place, doesn't mean it is something else. Addition, deletion or any type of number, that is also not allowed. See, Thunder Services Limited is same as Thunder 11 Services. Now guys, how do you check that whether a company with any identical thing is available or not? So guys, on MCA portal we have this facility. Check company name. Okay, so on our MCA has helped us over here. What? Say for example, my name is Prachi, okay, and if you guys are aware, your name should reflect what kind of business you want to do, okay. So if I want to suppose do teaching, so if I write word education, okay, search. This does not see what entered company LLP does not exist, then in that case Prachi Education Private Limited would be available to me. Getting my point? So say for example Prachi Foods, if I want to start somewhere with respect to foods, okay, search. See, Prachico Foods Resort Limited, Prachi Tea Food India Limited. Then in that case, this is already given, okay? Then in that case, I cannot use this name. Are you getting it, guys? See, can you see the screen? Supposingly, see what they told, addition of some word, okay? Or right, removing that word. जैसे अभी यहाँ पे Prachi tea they have added, okay? So if I remove this T and if I write Prachi Foods Private Limited, then I will not get, like there's no addition of India, Delhi or removal of Delhi, then that names are not available. So similarly, my name is, I want to start with Prachi Foods. So this company is already there, okay? Then in that case, I will not get this name. So this is what Prachico Food and Resorts, they are different. उसमें resort भी है, इसमें resort नहीं है. This is only restaurant business. Getting the logic? So if your name is identical to something, you will not get. Say for example, Sahara, general name I take Sahara, and I want to start with resort business. Let's search. Then this is not there. Then if I want to open, I can always open Sahara Resorts Limited. I can do that. Getting my point? So see, if it is not available, entered company LLP name does not exist. And in case if the existing ones are there, then in that case I will not get that name because they are already allocated to someone or the other. Clear? Is this clear logically, guys? So how do you find? Your MCA has this facility wherein you can go and search for that. Clear? So this is how you will get to know whether any identical name is available or no. So in case if it is available, please be sure you will not get that name for your company. Clear? Next is undesirable names. Rule 8 of Companies Act Incorporation Rule provide that undesirable names are those which are those names which in the opinion of central government are prohibited by national emblems and names, okay? So in case you cannot use your national emblems name in your name, so it is prohibited, you cannot use. Then the name includes a trademark registered under the Trademark Act. Say for example, now supposingly I will explain how it is, guys. See, check trademark. So yeah, what they are saying, say for example, if you are planning to start a company, okay, and your company, the name that you want for your company is already registered as a trademark for someone else, then you cannot incorporate your company. Say for example, you want to incorporate your company with the name called as Cello India Private Limited, okay. तो आपको ये काम करना है कि यार सेलो पेन प्राइवेट लिमिटेड या सेलो स्टेशनरी प्राइवेट लिमिटेड. तो अभी देखो, see this is your search the trademark. I just did a trademark search and उस सेलो के नाम पे so many trademarks are already registered in different classes, okay. So with this name you cannot incorporate your company because in any case these people, the trademark holders, should not be at a loss. Getting the logic? उनका ऐसा नहीं होना चाहिए कि our trademark is registered and someone else or some other company is getting the benefit of that, and that is also not allowed. Understood? So this is prohibited. Then next they say name is identical with or too nearly resemblance with the name of any LLP. So LLP having a similar name, you cannot start. And the name includes any word or words which are offensive to a section of people. Okay, so for you it will be normal, but in case any section, like any in India is a huge or too diversified when it comes to culture. So you have Hindu, Muslim, you have Sikhs, you have Christians, you have Parsis, you have Jains, so many communities, okay. So you have to make sure that the name you are applying should not be offensive to any section of people. It has to be a general name and it should not be offensive to anybody. Okay, the proposed name contains the word British India, then it is not allowed. Okay, at any form आप अगर British India आपके name में डाल रहे हो, then it is not allowed and it is just not allowed in as per India's Act. Okay, the proposed name includes the word state in case of a company is a not government company. So if you are not a government company and if you use the word state, it is assumed that you are a government company, which is not allowed. Okay, and the proposed name is containing only the name of a continent, country, state such as Asia Limited, Germany Limited, Haryana Limited or Mysore Limited, then it is not allowed. You cannot do like that. Okay, so these things are not allowed. You will have to have object in your name. So मैं ऐसे प्राची एशिया लिमिटेड नहीं रख सकती हूँ. Understood? So this is very important, guys. This ideally comes in exams, that please list out the rules for undesirable names. So one, national emblem. Second, in case if the trademark is already registered. So third, if there is a too much of resemblance with an existing LLP, if it is offensive to any section of people, if you are using the word British India in your name, if you are using state, even though you are not a government company and yet you are using the word state in your name, that is not allowed. And in case if you are only using the name of a city or a continent in your name, it is undesirable. Words or expressions which can be used only after obtaining previous approval of central government. So in case if you want to use the below mentioned things in your name, okay, you have to have prior approval of central government. See, rule 8b of incorporation provides that following words and combinations thereof shall not be used in the names of a company in English or any of the language depicting the same meaning unless previous approval of central government is obtained. So see, in case if you want to use the word board, commission, authority, undertaking, national, union, central, federal, republic, president, Rashtrapati, small scale industry, Khadi and village industry corporation, financial corporations, municipals, panchayat, development authority, prime minister, chief minister, minister, nation, forest corporation, development scheme, state statute, statutory, court, judiciary, governance, governor, the use of word scheme with the name of government, state, India, Bharat or any government authority or in any manner resembling with the scheme launched by central government or local government or any bureau. So ideally these things, no, these words are used by any government bodies or autonomous government bodies. Okay, so if you being any other entity, if you want to use such words in your name, because अभी मैं ऐसा read करूँ कहीं पे Central Bureau of Plantation, so what first thing would come to my head? It is a government body. Getting my point? So all these words, if you see, they somewhere are related to any government or any government oriented agency. So in case if you want to use these words in your name, you need to get approval from your central government. Okay, then precautions to be taken care before applying for any proposed name. One should be very careful while applying name. There can be rejection of name approval in following cases. Proposed name is identical, whether identical, resemble or phonetically, means in pronunciation. Okay, if to the name of any existing company or LLP, as I showed you. So if it is not same, spelling same nahi hai, but if the pronunciation is same or it is exactly identical to any existing company or LLP, you will not get that name. Second, proposed name includes, I told you, trademark, then it will not be getting. Word, class, category, subcategory of the proposed company is mentioned in web form, website के form में www ऐसा सब करके किया, then you will not get. Industry activity code of NIC is not found. Now guys, whatever work, if you have seen any incorporation, NIC code is one list. Okay, like whatever is your object, उसका एक corresponding code होता है कि and that I showed you the SIN number. Okay, this is the activity code of yours. So basically looking at that code we get to know that you are into food. Supposingly food है तो NIC code की एक list होती है. I will show it to you. National Industrial Classification. So NIC code list PDF. Here it is. I don't know how do I download it. Okay, so see guys, if you see NIC code A is for agriculture, mining, manufacturing, उन सब में सब क्लासिफिकेशन होता है. See 01 is for crop, 02 is for this, तो उसमें further classification also come. So ideally whichever activity you are doing will have a national industrial classification, एक NIC code होता है उसका. But supposingly if you are entering or planning to do any business जिसमें which you cannot find in this NIC code list, then that work or that particular activity will not be allowed in your name. Okay, so like food, manufacturing, mining, business, recording, photography, सब कुछ इसमें लिखा हुआ है. Okay, but if you want to do something which is just nowhere mentioned in NIC and that business activity you want in the, of course, because as per name act whatever business you want to do should reflect in your name. Okay, so abhi that business is such which is not supported in by NIC. Okay, and then if you put that activity in your name, because you have to put, okay, और उसका कोई corresponding NIC है ही नहीं, then in that case, okay, because there is no NIC code, this activity is not recognized by National Industrial Classification, that business activity will not be supported by name clause as well. Clearly understood guys? Okay, so this is about NIC code. Then the proposed name is found descriptive, that is it contains commonly used words and prefixes or suffix not used in the name. So commonly used words and prefixes like we used, okay, yeah, yeah, all that things you cannot use in your name. No significance about abbreviation used in proposed name. So whatever if you are using any short forms, okay, then such things are not allowed. Proposed name indicates words, finance, investment, capital, etc., where the proposed object of the company do not indicate. So in case if your name and object, okay, are not in correspondence with each other, then you will not get such name. Object mentioned in the form are vague and trademark cannot be ascertained. Okay, and that way also you will not get name. Name contains word like board, as I told you, you will require the approval of central government. Application made with restricted and undesirable name, systems will not accept that only. Proposed name if resembles closely to the popular or abbreviated description of an existing company, then it is not allowed. Previous approval of central government has not been obtained and attached with the application where any words or expression which likely to give that your company is a government company, and if you have not attached any approval from central government, then of course that name has to be rejected only. If the proposed name contains the name of a foreign country, then the applicant has to attach any proof of significance of business relations with such foreign company like MOU with the company, etc. In case proposed name includes the name of India and a foreign country like India, Japan, India. In such case, the name shall be allowed if there is government to government participation or patronage, and no company shall be incorporated with by using the name of any enemy country. So India Pakistan Limited we cannot do. Okay, then see guys, you will have to reserve a name, and once the reservation of name is done, you will have to complete the procedure of incorporation within 20 days, otherwise that name would be again disqualified. So see, as per section 4.4, a person may make an application in Web Spice Plus, that is simplified performer for incorporating any company, plus ING 32, and for change of a name, of course run you will have to use in prescribed form. The name of the proposed company, or in case if you want to change the name of the company. Now reservations of a name lays down that upon the receipt of application, registrar on the basis of information and document reserve the name for only 20 days, okay, from the date of approval. And in case the application for reservation of name or change of its name, then it will be for 60 days. Suppose you are an existing company ABC Food Private Limited, okay. Now you want to change the name, okay, and you've made an application, okay, कि मेरे को भाई XYZ Food Private Limited करना है. Then this XYZ, if it gets approved, you can hold it for 60 days because you are an existing company. But if you are a new applicant, you want to start a new thing, then only 20 days that they will hold the name. And in case if you do not complete the incorporation procedure within 20 days, then that name reservation will go and it will be available for any other person also. Common reasons: proposed name is not according to the activities described in the main object. Say for example, I will be doing manufacturing and in my name I give food, then in that case it will be rejected. So your name should reflect your main object. Proposed name is not available in view of existence, or something is existing is already there. Proposed name is too general. Keywords like industry, udyog, enterprise, product, manufacturing may be considered when the company proposes to deal in various business activities. In case business activities in particular trade से keyword cannot be allowed. Okay, so आप ऐसे general words use नहीं कर सकते हो. Okay, if you are in some particular area, you have to specify that only. Words like industry, etc. will not be allowed. Proposed name includes national, central, ये सब भी नहीं allowed है. Section 4.5 provides that wrong or incorrect name information in the name reservation application is, if it is found that the name was applied by furnishing wrong information, then of course the reserved name would go cancel, and the person who is making this will be penalized for up to amount of 1 lakh rupees. Now further, if the company has been incorporated, okay, already incorporated, and if you are planning to change your name, okay, then after giving, then either direct the company to change its name within 3 months, or take the action of striking off only directly and make a petition of winding up. So it can be that severe. So if you are doing any fraud, okay, for reserving the name, then in that case such intense actions also will be taken. Clear? So this is about the name clause, a too detailed study. So how are you supposed to name your company जिसमें object reflect हो? It should not be in close resemblance. So those examples we have studied, खाली s लगा दो, tense change कर लो, that are not allowed. Okay. Then if you want to use corporations, boards and such words, you need a prior approval of your central government. Then undesirable name ka those list are that you have to study. So this is about, so if you are a new person, it will be reserved for 20 days, and if you are an existing person who is planning to change the name, then that name would be reserved for how many days? 60 days. Okay. And what are the penal provisions in case if you are doing any fraud or if you are furnishing any wrong documents to get a name? It will be, penal provisions would attract 1 lakh rupees, and in case if you are a company, then of course they will ask you to change the name of your company within 3 months, or they may even order for striking off and winding up also of your company can be done. Clear? So this is about your name clause. Is there any doubt? Then you are free to contact. This is about your name clause. Now we shall start about the situation clause. Now we were talking about the situation. So what do you mean by situation? Basically the place where the registered office of the company would be situated. Now why is this important? Because that particular ROC would come into picture. So the state where you are incorporating the company, uske ROC ko you will have to report for everything. So first purpose that. Then wherever your registered office is, all the formal communication to your company would be made on that particular office only. That's why address clause is very important. Now guys, while you are incorporating, okay, ROC gives you a time that first you just have to decide the state that you will have to compulsory mention, okay, and within the 30 days of your incorporation you will have to give the exact registered office address. Okay, by we will be doing the business here. State you will have to say because the ROC would come into picture. So say for example, if you're starting in Karnataka, you will have to give that, okay, situation clause is Karnataka. The place of business would be in the state of Karnataka because the stamp duty of Karnataka, registrar of companies, everything from Karnataka would come into picture. Secondly, when you are giving the authorized capital, okay, so with what stamp duty you will have to pay on that. For that purpose also we will need to, because you know Stamp Act is state wise. So for that purpose also you need to know the state of the company. So which state you want to start your business, that you will have to mention in the situation clause of the company. Clear? Then next is in case if you are not sure with the registered office, you can always give the address of a correspondence. So for now this is your address, and within 30 days you will have to file a form to ROC and state where exactly will be your registered office located. Clear? So this is about the situation clause. Now guys, your address is very important, because on all your letterheads, all your official communication, the seal of the company, whatever it is, everywhere this has to be mentioned. That's why this is something which is very important. Okay, so what they say, the name of the state in which the registered office of the company is situated must be given in memorandum, but the exact address of registered office is not required to be stated. According to section 12 of the act, within 30 days of the company's incorporation within 30 days of company's incorporation and all times thereafter, the company must have registered office to which all the communications and notices may be sent. Clear? Now, verification of the registered office. The company must also furnish to the registrar verification of his registered office within 30 days of its incorporation in such a manner as may be prescribed in Form INC 22. However, it will be noted that E-Form INC 22 is not required to be filed with Spice Form Plus if a company is registered with the same address as correspondence address. So, if your corresponding address is same as registered office address only, then no need to do your INC 22, because it is already the same, so it is already been furnished to ROC. In case registered office is different, okay, so in case if your corresponding office and registered office is different, that's when you will have to file INC 22 within 30 days of incorporation of the company, intimating about the office address. Now, why it is needed? The obligation of a company regarding registered office. According to section 12.3, every company is required to display its name and address in legible letters, in conspicuous positions, and in all its business letter, bill heads, letter paper, everything. Accordingly, the company shall paint, affix its name, address of a registered office, and keep the same painted or affixed on outside of every office or place in which the business is carried on. Okay, in conspicuous position means clear position, ऐसा नहीं कि छुपा के रखा है, it's clear, it's legible, it's open to all. Okay, and if the characters employed thereafter therefore are not those of the language or one of the languages in general used in that locality, also in the character of that language. See, if supposingly I have written the board in English, but the registered office where I am or the place where I am working, say for example it's a small village and majority people doesn't understand that language, okay, और वहाँ पे लोग suppose they are talking only in Marathi, they don't understand or they don't know how to read in English, then I will have to write the name in Marathi also. Okay, then have its name engraved in eligible character on its seal. So wherever the company is putting, initially we had the concept of common seal, which we are now done away with. Okay, get its name, address of its registered office, and the SIN along with telephone number, fax if any, email, website, etc. should be printed on the business letters, bill heads, letter papers, and in all the notices and all the official publications. So in case if anyone wants to contact to the company, they have all the contact details available. Okay, then have its name printed in all the negotiables. So that is all your Hyundai's or all your promissory notes or whatever you are giving. Okay, negotiable act के अंदर जो भी आता है, और all of that also you will have to print. If it has a website for conducting any online business or otherwise, shall disclose, publish its name, address of its office, SIN, telephone number, fax if any, email, and the name of the person who may be contacted in case of any queries or grievances, everything. However, where a company has changed its name or names during last 2 years, it shall paint or affix or print as the case may be along with the name the former name of last 2 years. So today if I am changing my name, okay, name of my company, for next 2 years that old name also has to be printed, okay, formerly known as so and so. Understood? So that people who are trying to communicate knows exactly what is your name. And okay, because in like couple of days I haven't contacted to you, and if you have changed your name and if I have anything against you, I want to tell something to you, how I know what is your name. Okay, so for that purpose, so that kuch galat na ho, one has to keep their old name painted on the new ones. Clear? Then the further in case of OPC, the word OPC shall be mentioned in the brackets, that we have already known. CA wide notification, very important guys. 18th August has notified third amendment rule, which has come into force on the date of publication in official gazette. According to amendment 25B, a rule is inserted stating physical verification of registered office of the company by registrar in terms of 12(9) of the companies in presence of 2 witness of the locality. So registrar would come to your place personally and 2 local person would stand, and in their presence the registered office ka jo address hai has to be verified. Because sometimes you know what happens, people give any fake address, सब कुछ fake करके एक office बना देते हैं, and you are trying to communicate, there is nobody over there, so you will have to come personally. They will come and they will check. Registrar shall carry the documents as filed on MCA in support of the address of the registered office of the company for the purpose of physical verification. Take photographs of the registered office. Further, a report of physical verification of registered office of the company is also required to be prescribed in the prescribed format. So now registrar will take a picture of your office, that this is the premise in which you are working, and that also has to be reported. So nowhere a fraud can be done. Clear? So this is about very important. So this is something latest which has come. So there are chances of this coming in your exam also. So latest by August 22 this has happened, wherein a physical verification has to be done of the office. Registrar will do that. They will take photographs and in a prescribed format that report will be submitted. So whatever incorporation documents may registered office ke liye, whatever documents you have filed, they will carry it along with them and they will do the physical verification of the records. Is that clear to all of you? So this is about your registered office. Okay. Next is the object clause, as we all are very much aware about it. The third compulsory clause in the memorandum sets out the object, okay, for which the company has been formed. So basically this will tell you that why a company has come into existence. Under section 4(1)(c) of the Act, all companies must state in their memorandum the object for which the company is proposed to be incorporated and any matter considered necessary in furtherance of thereof. It indicates the purpose for which the company has been set up and its actual capability. Besides its sphere of activity, it states affirmatively the ambit and the extent of powers of the company. Okay. Stated negatively, nothing can be done beyond this. Now the objects are divided into main object and any matter considered necessary in thereof. The main object of the company gives a brief about the activity that are decided to be carried on by a company. The main object of the company generally include the activities like manufacturing, trading, providing any kind of services by the company. Further, another subclause, any matter necessary, that describes the activity incidental to the main. As I told you, that under the object clause you have 2 things, main object and ancillary objects. Ancillary are the support activities to the main object. Okay, suppose if you are manufacturing cloth, so cloth ka koi bhi by product hoga, you can work in that also. So that manufacturing cloth would be your main object. Uske ancillary, like if manufacturing of cloth se cloth ka koi bhi by product hai to uska stitching karungi ya this, that would be your ancillary object. So something which is in line of your main object but which will support your main object. Okay, so this is your ancillary object. Okay, liability clause, as I've already told you, in case of company limited by share, liability of its member is limited to the amount of unpaid, if any, on share. Company, in case of company limited by guarantee, the amount of, in case of winding up only, that guarantee would trigger and it would come into picture. So to the assets of the company in the event of being wound up while he is a member or within 1 year after he ceases to be a member, for payment of the debts, liabilities of the company or such then as may be contracted before he ceases to be a member, and to the costs, charges and expenses of the winding up. In MOA of Tata Consultancy Services Limited, it provides that company is limited by shares. Then company limited by liability clause, may basically 3 you have. Limited by share, as we know, up to the unpaid value of share, up to the guarantee when it comes in the case of winding up, and unlimited means all your personal property also would come at picture. Next is your capital clause that will tell you about the authorized capital of the company. Means that is the maximum ceiling of capital. See, in case of company having share capital, the amount of share capital with which the company is to be registered and the division thereof into shares, fixed amount. So, say for example, if you are starting a company with authorized capital of 10 lakh rupees divided into a lakh shares of rupees 10 each, that would be your capital clause. This clause shall state the amount of capital with which the company is being registered. The shares into which the capital is divided must be having a fixed value, which is commonly known as the nominal value of the share. The capital is variously described as nominal, authorized or registered capital. The amount of nominal capital is determined having the regard of the present as well as future of the company. The usual way to state the capital is the share capital of the company is 10 lakh rupees divided into 1 lakh equity share of 10 rupees each. This amount lays down the maximum limit beyond which the company cannot issue shares. So there is a difference between authorized and paid up. So this is your authorized capital. If there are both equity and preference, then the division of the capital is to be shown under the two head. A company is not authorized to issue capital beyond its authorized nominal or registered capital. So these are one and the same thing. If it receives application for shares beyond the shares covered by authorized, the amount received in excess should be returned, because this is the charter. As I told you, you cannot go beyond your MOA. So whatever is written, that is final. इसके बाहर का आप कुछ भी नहीं कर सकते. Clear? Then out of the issued capital, total amount actually subscribed or agreed to be subscribed is known as subscribed capital, and this subscribed capital again may be wholly paid up or partly, in which later case the balance would be payable on future calls made. The amount actually paid by the shareholder is called as the paid up capital. This all I have told you. I think subscribed capital, paid up capital, I have told you who is the subscriber, who is the shareholder, who is the member. So this authorized capital, subscribed capital and paid up capital. Clear? This is called, these are the types of your capital. And the last is your subscription clause. Okay, so who are the subscribers? So they are the initial members of your company. The number of shares which the subscriber to the memorandum agree to subscribe shall not be less than 1 share, and the number of shares each subscriber to the memorandum intend to take it's indicated in the opposite. In case of OPC, the person, of course, 1, and in the event of the death of the subscriber, nominee shall become the member. The subscriber sheet में ये सब details होती है. Name of the subscriber, details like, so how, supposingly if it's me, then Prachi Shah, daughter of Harshad Shah, that is father's name, complete address with the valid PIN code, so whatever it is, PAN card, BOY, whatever it is, signature, okay, signature. Then the subscription sheet needs to be mentioned with the total. Okay, so ये मेरी detail डाली. Opposite में number of shares that I have subscribed to taken, so I will have to write 1 equity share of rupees 10 each. If the subscriber is a company or a body corporate, signature, and then on the sheet there will be a column of witness who would, ideally a CS does the witness thing, so they will do the authentication. Okay, whatever it has been, these all people have signed in front of me. Okay, and that has to be attached to the memorandum of company. Provisions in the memorandum or article is what? According to section 4.7, any provision in the memorandum or article in the case of company limited by guarantee not having share capital purporting to give any person right to participate in divisible profit of the company, then that member shall be void. Above clauses are compulsory and are designated as conditions prescribed on the basis of which the company is incorporated. It is to be noted that Companies Act 2013 shall override the provisions in the memorandum, article or resolutions of the company if the latter contains anything in contrary to section 6. So in case if anything, if you are incorporated in any old act, okay, and if any provision is in contrary to Companies Act 2013, then all that thing will go void. Now this is what they are trying to tell you. I was trying to show memorandum. It is ideally a document, okay, now companies which are listed, तो उनकी साइट से भी मिलता है मेमोरेंडम. So you can see MOA of Reliance. Let's see in case if you get. See, memorandum, this is the CS Savitri. Annexures to the MOA, High Court sanctioning schemes, etc. Certificates. Fresh certificate of incorporation consequent of name change. So can you see? Reliance Textile Industries Limited to Reliance Industries Limited. May 1973. Certificate of register of the order of the company confirming this. It's too complicated, guys. Certificate, I hereby certify that My Nylon Limited. It started with this, okay, My Nylon Limited, given under my hand at Bangalore. This 8th May 1895. Memorandum of Association. See, Reliance Industry Limited. This is the name clause. If you guys can see, main object. This is the main object, and the objects incidental, and this to the main object. So ये सब object clause है इसके Reliance Industry के. Other objects not included in A and B. So this many are the objects of Reliance. Okay, object clause only you see. Draft करने में पागल हो गए होंगे. See, inserted. So all this object clause alterations के dates you see. It started with 1993, 78, 84, 96. So all these alterations have happened in this. Then the authorized share capital of the company is this much at the time of incorporation, modified from time to time. So see, from incorporation till now, subsequent modification. By passing resolution at the this dated 13 September 2022. This, what is the authorized capital now? Wait, 14 crore, and total authorized capital is, I don't know how to calculate this. Once 10, 100,000, 10,000, lakh, 10 lakh, crore, 10 crore, 100 crore. So 150 crores is the authorized capital if I'm not wrong. Okay, so इसमें और subsequent alterations हुए हैं, and I think 13 September is the last day of authorized. And see, subscribers to this. Oh, see, it was started with Bangalore only. So the initial subscribers you see. Son of this address and subscribe shares. Satish Chandran, Shishadri, Uttarraj, I don't know, and this was the CS who has verified this. 4th May 1973, and this is the AOA that we will do wait, but this MOA. So did you check out all the clauses? Name, address, see, memorandum, registered office of the company, state of this, name, the objects we have seen, other objects, other objects, other objects, capital we have seen, liability of the member is limited, the authorized capital of the company is limited. So this is company limited by share. This is the 5th clause of MOA, and the authorized share capital is so and so, which they have given, and all the rupees 15,000 crore only. So this is their authorized capital, and they have given you the table order alteration, and this is the subscription. So these are the 6 main clauses of any MOA. Clear, guys? I hope you all are okay with MOA. So all the 6 clauses and how are you supposed to write your MOA. So name clause, we have checked all the list how you're supposed to name a company, which are the undesirable names, and how ideally the naming of anything happens. Okay. Then we spoke about objects, how are you supposed to do. So main object and your ancillary object and other objects if any, all that has to be mentioned. Liability, capital situation, so where exactly the registered office of the company would be situated, and all the allied norms with that. So this is about, and the subscription clause, of course, that is the last page, who are supposed to sign it. Okay, we are the ones who are the initial members of the company. So this is your MOA. I am giving you 2 minutes time. एक बार देखो, that's when we start with AOA. Yes guys, let's start with AOA. Now articles of association, we have, I think, spoken about MOA and AOA together only. Now guys, like how MOA gives you the scope, okay, this is the borderline within which you have to work. Okay, okay, this is the scope, these are the powers of any company, whereas article is a document which will give you or which will govern the way you work. Okay, so supposingly your object is to manufacture, then how are you supposed to do that? That your articles will tell you. So your MOA defines the scope or the purview within which you have to act. Okay, and how you will act, the way of working, your articles will say. Okay, so article is basically a document which is subsidiary of MOA. So MOA sets out the limits within which you have to operate. AOA will give you the guidelines how you are supposed to act. Okay, so आपका capital इतना ही है. अब how you are supposed to use that capital, how you are supposed to do the borrowing, how are you supposed to raise new capital, issue public, वो जो सब कुछ होगा. So basically the rules, the ways, the procedures that you will have to follow while you are working, your articles will tell. Okay, so MOA will give you the borders within which you have to work. AOA will tell you how you are supposed to work. So in case if you want to issue your increase your suppose you want to issue any capital, so how are you supposed to do that? That your AOA will tell you. Okay, so how much money can you take from your members? हाँ, of course you cannot violate any provision. Companies Act तो है ये, वो ऊपर है, उसके अंदर you have to form your MOA and AOA. Okay, so you cannot violate the sections, but how your company will abide those sections, what procedures, what way of working they will follow, that your articles will tell you. Clear, understood? So according to 2(5), articles means articles of association of a company as originally formed or altered from time to time in pursuance of any previous law of this act. It includes the regulations contained in table A of schedule 1 of the act in so far as they apply to the company. In case of private company, the provisions of table A may be altered to suit the specific requirements of the company, provided any such should not be in contrary to Companies Act 2013. The general function of articles have been aptly summed up by in this as follow. Article play a part that is subsidiary to the memorandum. They accept the memorandum of association as the charter of incorporation of a company, and so accepting it, the articles proceed to define, please underline all this, define the duties, rights, powers of the governing body as between themselves and the company at large, and the mode and the form in which business is to be carried on by the company. Okay, so internal regulations basically. So internally how a company will regulate and work and operate is your articles of association. The memorandum is as it were the area beyond which the actions of company cannot go, and inside the area shareholders may make such regulations for the governance of the company as they think fit. Thus memorandum lays down the scope and power. Articles governs the way in which the object of the company is being carried out and can be framed altered by the member, but they must keep within the limits marked out by the memorandum and companies act. Okay, so how you are supposed to do it? That is the internal working of the house is your article of association. The articles of the companies are subordinate and subject to MOA and the act. Any clause in article going beyond the memorandum will be ultra virus. मतलब आप कर ही नहीं सकते हो. Say for example your authorized capital is 10 lakh, so by any chance your paid up cannot go beyond 10 lakh. So in case if your article even gives you power, you cannot go, by itself becomes ultra virus. Reason being it is going beyond the memorandum of association. Clear? So what they say, articles are only internal regulation over which the members of the company have full control and may alter them according to the way they think fit. Okay, only care has to be taken that article do not exceed the power of company laid by memorandum. Okay, Ashbury Watson case that go beyond the company's sphere are inoperative from that time only. Section 7, when provided at the time of incorporation of the company shall file with registrar within whose jurisdiction of course the registered office is situated the memorandum and articles duly signed by the subscribers in the prescribed manner. Every type of company, whether it is a public or a private or whether limited by shares or by guarantee or an unlimited company having share capital or not, articles of associations are must. Entrenchment provisions of article. The article may contain provisions for entrenchment to the effect that specified provisions of the article may be altered only if the conditions or procedures that are or more restricted than those applicable in case of special resolution or met or complied with. Okay, so entrenchment, what do you mean by entrenchment, guys? Entrenchment means that change of those is very difficult. So there are certain clauses in the articles which are entrenched, means you cannot change them easily. For that special resolution or certain set of procedures have to be prescribed with or has to be followed. Okay, so the provisions for entrenchment referred to in section 5.3 shall be made either on formation of the company or by amendment agreed to by all the members in case of private company and special resolution in case of public company. Okay, so certain clauses can be altered only in case of 100% voting in case of private and in case of special resolution when it comes to public company. Where the articles contains provisions for entrenchment, whether made on formation or by amendment, the company shall give its notice to the registrar and spice firm at the time of incorporation or in e-form MGT 14 in case of existing company. The articles must be printed, divided into paragraphs, numbers, stamped, adequately signed by each subscriber, etc. Contents of article. So what all things are listed in articles of association? Either it will be adoption of any of this. Okay, so the article set out by the company for it, the article should contain generally an exclusion wholly or in part of table dismissing adoption of any preliminary contracts. So in case if your company has made any contract before coming into operation or incorporation, then what will you do with those preliminary contracts? Articles will specify that. Share capital and variation of rights if any. So what are your rights of your shareholder, and in case if you are giving shareholder on any variation rights, that also has to be specified. Term governing issue, redemption of preference shares, terms of allotment, calls, lien, transfer, transmission, nomination, forfeiture, alteration of capital, buyback, then general meeting. Say for example, see a Companies Act says 21 clear days notice has to be given minimum. Okay, so article में how you are supposed to give notice, you will give that, but ये जो clause है you cannot contravene that. Okay, so you cannot go beyond your memorandum, you cannot go beyond the act. That is very important. Okay, share certification, dematerialization, conversion of shares into stock. So what all procedures the company will follow in case of, this is the internal working. So internally how you're supposed to work, this is what your article tells. Then voting rights and proxies. So in case if you have appointed proxies, Companies Act के provisions तो follow करने ही है, but in case if companies have some extra provisions, you have to tell through articles. So this all the things that you will have to comply with in case if you are appointing any proxy for the meeting. Directors, their appointments, delegation of power, nominee of directors, issue of debentures, audit committee. So how will audit committee meet? In case if there is a meeting of audit committee, how notices are supposed to be served, everything would be prescribed in your AOA. Then what is the seal, how remuneration to the director would be paid. Okay, so maximum limit is 11% as per Companies Act. So how would you disburse that remuneration, all these things. So how will your general meeting will be there, how would you write down the minutes, how would be the board of directors preceding, borrowing, winding up, capitalization of profits, etc. Utmost caution must be exercised in preparation of articles of the company. At the same time, certain provisions of the act are applicable to the company, notwithstanding anything contrary to the articles. Therefore, articles must contain provision in respect of all matters which are required to be contained therein, so not to hamper the working of the companies later. So whatever is needed, everything has to be mentioned clearly in the article. Now see, section 5 of the act provides articles should be in any form F, G, H, etc. Form table F is applicable to company limited by share, G is applicable to company limited by guarantee having share capital, not having share capital, and table I shall be applicable to both companies having this. Precautions to be taken while framing the articles of association. Articles must be divided into paragraphs and numbers consequently. It shall not contain something that is contrary to memorandum. Anything that would be stated or amended in article shall be in accordance to Companies Act. So two things you have to remember, nothing beyond MOA and nothing beyond Companies Act. Okay, so this is how it works. This is your Companies Act, uske andar is your MOA and uske andar is your AOA. Okay, so this is the thing, uske beyond you cannot go. Okay. Now, for example, 272 of Companies Act states that contributories right for presentation of petition of winding up in any circumstances. This right cannot be limited by the articles. The articles shall be signed by each subscribers of the memorandum who shall add his address. Subscribers shall sign articles in presence of at least one witness who shall at least signature and shall add his name and address and description. So we were seeing the MOA of Reliance. Let's see articles also of Reliance Industries. I will show how it is ideally. So we saw the MOA, articles of association. See, table F, because it was company limited by shares. Okay, shall not apply, table F, not to apply, company excluded. Okay, the regulations for the company to be governed by this article, Act, articles, board of director, company means this, rules means ये सब उसका पूरा explanation दिया है. Shares under the control subject to the provision, the shares in the capital of the company shall be under the control of board. Directors may allot share otherwise than cash. Kinds of share capital, so this with equity, voting rights. So this is what each and everything they have said. Issue of certificate to bear seal. So जो भी सब कुछ है, everything. So how lenient, see every clause they have taken care of. Calls on shares, how are you supposed to make the calls on your shares? So everything would be taken care. Transfer of shares, so in case if the transfer of shares is happening, how are you supposed to do that? Reliance में transfer कैसे होगा? It will be done this way. Okay, so this is your articles of association. Sometimes, you know, when a Companies Act is silent, then the company gets the power to do certain things through MOA and AOA. So you have to be very much sure, very much careful while you are drafting your MOA and AOA that you are not missing out on anything. Whatever is needed, whatever is compulsory, everything is there in your MOA so that your working is not altered. Clear, guys? So this is about your MOA and AOA. Now in next recording we'll be doing how are you supposed to do e-filing on your MCA portal, what all professional as a formation of a public limited and a private limited company, what all requirements, what all prohibitions are there. Incorporation of section 8 company. So we'll see the incorporation of all types of companies. What is certificate of incorporation, what all precautions you have to take while you're incorporating a company. So very detailed thing we'll be doing. So whatever we have studied so far, steps of incorporation, process of incorporation of OPC, we have done so far. In reality how it happens, tomorrow I will show you various types of forms also. तो आप देखना स्पाइस फॉर्म IMC 32 वो सब कैसा होता है. So tomorrow I will show you all of that. So next lecture we will see how are you supposed to do the filing basically. Okay, so in today's class we have spoken something really important from any company's point of view. So we have taken care of what is foreign company. We have seen what is MOA, what is AOA. So in foreign company we saw how are you, what all filings were needed, section 379 to 393 if I am not wrong. Okay, so all that we have complied with. We have seen what is MOA. MOA के 6 clauses we have seen. We saw what is AOA, what basically you have to do. Okay, so this is for your today's class. This was very important. Now in the next recording we'll be completing this class wherein I will tell you basic how you are supposed to file. तो IMC 32 कैसा होता है. So see, while you are incorporating you will have to give name, address, you will have to give the capital. So how will you furnish all these details on your ROMCA website. Okay, how basically it will differ for private limited and public limited, all this we will talk in our next recording. So please don't miss that. And tomorrow we'll be completing this chapter as well, that is in our next session. And I hope today you guys were clear or you had a complete clarity of this concept which I have spoken about. Thanks for being there, and I hope I did justice to whatever was being taught. Okay, so on this note I end my today's class. Okay, thank you for being there, thank you for watching, and see you all up till I record your next video for incorporation. So how will you do the incorporation, that will be seen in our coming recording. Thank you so much. Bye for now. Hoping to see you all next time. Bye. Thank you.